Welcome to today's webinar on oil and gas law. My name is Alice Hogan. I'll be your instructor. I wanted to start with a little joke. Boudreaux went to New York City, and man, he was trying to impress the people around him. And so he went into a fancy restaurant and he ordered a hamburger. It's a famous hamburger joint in Times Square. And he ordered a hamburger. And to impress the waitress, he said, "Please cut the rice." Okay, so if y'all are from Louisiana, you get that because rice goes with everything. Okay, so let's then begin with oil and gas law. Let's look at what we're going to go over. Now, this is a class that's taught in law schools across the country. Obviously, you know, it's more popular in states where there is oil and gas production, like Louisiana and Texas, and now I think Pennsylvania. But not all states have it on their bar exam. For example, I'm from Louisiana, and they did not have it on the bar exam in Louisiana. But I know for a fact that they do in Texas. So in Texas, in order to become an attorney, you have to pass the oil and gas law section of the bar exam. So what I've tried to do here is just to sort of take that semester-long course that's offered in law school and condense it down to a one-hour presentation. Not very easy to do, but we're going to give it a shot. So let's then look at what oil and gas law is. We're going to start with what we call ownership theories, or something historically called the ad Coelum doctrine. And that was replaced with the rule of capture, and there's also different ownership theories. So once we know these laws, then they're modified, specifically this rule of capture is modified by this, the doctrine of correlative rights. So we're going to talk about what those are, and then we'll talk about the rights of the mineral owner, and then we'll talk about how those rights are protected, typically by a lawsuit in trespass. And then I'm just going to introduce you to the implied covenants of the lease because this is something that we have a pre-recorded webinar out there for. So you should be able to view that. But I just want to kind of give you a little heads up about it. Okay. All right, so now let's look at the ad Coelum doctrine. Now this was what the law was before the discovery of oil and gas. And what it says is, in Latin, whoever owns the soil, solum, is theirs all the way up to heaven, Coelum, think about celestial, and down to hell, inferos. So, cuis est solum, eius est usque ad Coelum et ad inferos. So, in other words, the theory of law was that if you owned the land, you owned all the way down to the center of the earth and all the way up to as far as the sky would go. So all the way up to heaven and all the way down to hell. That's also known as the heaven to hell principle. Now, the ad Coelum doctrine was tested with the development of oil and gas. Specifically in this case, this is called Del Monte Mining versus Last Chance Mining. This is a 1898 case, but what happened is that chance followed the mineral vein. Now this was silver, okay? This was when we were talking about hard minerals, which we'll also cover in week 3. Silver, not oil and gas. So it was mining that beyond the boundaries of its claim and beneath the surface of Del Monte's claim. So what happened was he was, had this silver vein on his property, and he's digging and digging and digging out the silver vein, and the silver vein continues to go through his neighbor's property. So who owns the right to that silver vein? Since it started on his property, does he own it, or does the person that owns that particular property own it? And the court held, of course, that the owner and fee of the soil owned all below the surface, limited by the extent of the surface rights. So whoever owned the mineral itself, whoever's property that mineral interest was on, he was the owner of that mineral interest. So you were limited to what was actually on your soil. Now the ad Coelum doctrine The ad caelum doctrine then was tested by Orville and Wilbur Wright with the invention of the airplane. Because if the owner owns all the way to the heavens, what gives the airline the right to fly over your land? And the question was, how much of the airspace did the owner of the soil have the right to control? And the answer that came back was only as much as he can reasonably use. So, if an airplane flying above the earth is not something that a normal human being can access. So that is airspace that's available to everybody because it's not something that can be used by the surface owner. So the question was, is the owner of the soil entitled to the minerals under his property? That's what the case of Del Monte versus Last Chance Mining was. And the answer is yes, if those minerals are solid. But oil and gas is not solid. Oil and gas moves. It is called what they call in the law fugacious. Fugacious means that you could have oil and gas on your property, and that oil and gas could flow to the property of someone else. So the minerals on your land are not yours. They belong to wherever the oil ends up on. So let me give you an example. So because oil and gas was fugacious, or oil specifically was fugacious, courts had to come up with a new ruling. Okay, yeah, we know if there's a silver mineral vein under there, that whoever's property owns that right to that silver vein, and if it crosses to another person's property, that silver vein then becomes the other person's property. Not so with oil and gas, because oil and gas could be under your property, but it could also move to somebody else's property. So just because it's on your property at a given time doesn't mean you necessarily own the minerals. So let me show you how this works. Courts decided to compare the movement of oil to the law that applied to wild animals at the time. And this was called the rule of capture. So, oil and gas is found in the earth. They used to think it was, big pools of oil under the earth. But today we know that that's not the case. What it is really is rocks. And embedded in between these rocks, like this, is where the oil and gas is. So if an owner drills on his property, he is draining the land of his neighbor. So even though those minerals were on this neighbor's property, because the neighbor B drilled an oil and gas well, that's going to make pressure draw this oil to landowner B's property. So the question was, is that fair? Well, they looked at two different things. One, the fugacious nature of oil and gas, that is, that it travels. The other is that they are fungible. Fungible in the law means it's exactly the same. There's no distinction. So if you and I agree to, buy what's it called? Shoot, I was going to say a barrel of wheat. I can't think of the term. Whatever it is, a bushel of wheat. God dog it. Okay, a bushel of wheat. And I gave you a bushel of wheat, you couldn't then say, well, wait a minute, I wanted that bushel of wheat, not this bushel of wheat. Because wheat is fungible. One is just like the other. There's no way to distinguish one from another. I had a friend in law school who would say that men are fungible. There's no distinction between one or the other. I don't think that's right. But that's just a funny way for you to remember what fungible is. So in this case, it's important because there is no way we can tell from this well whose oil it is, because everybody's oil looks the same. So that is the unique nature of oil and gas that required it to have a separate law than hard minerals, like in the Del Monte case. So what the courts came up with is what's called the rule of capture, and they based this on ownership of wild animals. All right, I'm from Louisiana, so if I'm in Louisiana and I see a duck flying through the sky. Who owns that duck? Well, you could say nobody owns that duck. It's a wild animal. It's free. Or you could say we all own that duck. Okay? But let's say you say that it's a wild animal and it's free. Nobody owns the duck that's flying in the sky. But if I take my gun and I shoot that duck on my property, that duck becomes my property. So once you, what's called reduce it to possession, that's once you make a wild animal your specific property, it then becomes yours. And in the same way is oil and gas. Oil and gas under the earth is free. It's wild. So who owns it? Well, nobody really owns it, or, we all own it. Either way you want to look at it. But once a landowner drills on that property, he becomes the owner of the duck, or he becomes the owner of all the oil and gas under the earth, because he was the one that reduced it to possession. So let's look then at the rule of capture. And what it says is that the landowner who extracts oil and gas from beneath his land acquires absolute ownership of those extracted substances, even though they may be drained from beneath the land of another. So the idea is you drill it, you've captured it, you own it. So that's very important. Whoever drills it owns the property. So let's look at some exceptions to this rule, and one is drained oil and gas. So you can't have a well on your property and then you slant it into your neighbor's property, all right, and say, hey, rule of capture, I'm the one that owns it. No, you don't. You only own what's on your land, okay? You can't go veer off into someone else's land. So when we do horizontal drilling, what we have to do is we have to take a lease from every person that our drill bit is going to pass under their land. So we're taking leases from all these people. So you can't just have one well and slant into the neighbors. That is called a slant well drilling, and it's also known as trespass. You can't negligently blow out oil. So let's say that this person owns the oil and gas under his ground, and he doesn't do a good job with the oil well, and so the oil blows out. There's a negligent blowout of the oil well, and there's fire, and it causes the reservoir to decrease. Well, you can't say rule of capture, it was mine anyway. So if I have a blowout, that's nobody's business but mine. Well, that's an exception. No, yes, you own it under the earth, under your property. And if you drill it, you do own it. But that does not give you the right to abuse the reservoir. And so a negligent blowout does not fall under the rule of capture. Nor does stored gas. There was this case called Champlain Exploration versus Western Bridge and Steel, Inc. It's an Oklahoma case in 1979. And what I want you to recognize about this case is, even though, let's say we're in Texas, for example, and this is an Oklahoma court decision, why is the Texas court bound by this Oklahoma decision? Well, it's because Texas law then followed this. So all the states that were oil and gas producing states began to follow this. So this was the first case like this. And what happened was there was a company came and asked Western Bridge and Steel, Inc., if they would store gas on their property. Maybe they had a salt mine underneath their property, and could they store the gas onto their property? And, Western Bridge and Steel said, sure. And so then Western Bridge and Steel said, hey, it's on my land, rule of capture, I now own this gas. And the court said, no, that's not the way it works. If you give someone permission to store gas on your land, you then cannot tap into that gas and say the rule of capture. So let's then look at a hypothetical. Now, in law school, this is what they did all the time. They would give you these ridiculous hypotheticals, and then they would call on you, and they would literally just ask you question after question after question after question. I remember one time in 2 classes I was called on. And once you're called on, that's the whole class. The whole hour is going to be spent with them grilling you. And so I remember that day going home, I just felt like a rag doll. I just felt like all the stuffing had been taken out of me. So let's give you a hypothetical, and here it is. Let's say that a landowner owns 10 acres of land. If she drills an oil well on her 10 acres, it's going to drain oil from a 40-acre radius. In other words, oil is going to come from someone else's property. If she drills a gas well on her 10 acres, it will drain a gas well from a 640-acre radius. So she owns 10 acres. If she drills a gas well, she's going to drain it from 640 acres. So the question is, what rights do the neighbors have? So let's say the landowner drills a well. Do any of her drained neighbors have a right to share in production from that well? Raise your hand if you think they do. And the answer is no. They don't have a right to share in the production from this well, even though she's draining them because of the rule of capture. Under the rule of capture, if you drill on your land, whatever oil and gas that flows to your well becomes your oil and gas. Okay, so can the neighbors then get an injunction to shut in her well? Your Honor, we understand that she's draining our oil. Can you get an injunction? Can you stop her until we can get our wells up and drilling? And the court's going to say no. We're not going to get an injunction for her to shut in her well because under the rule of capture, she has the right to drill on her property, even though it's going to drain your wells, your minerals. Can the neighbors then seek damages for drainage? Okay, Your Honor, well, maybe we can't stop her, or maybe we can't get a share in the production, but can we sue her for what the drainage that she's causing from our property? And this is where the fugacious nature of oil and gas comes in, and the fungible nature of oil and gas, because there's no way for us to tell of the oil coming out of the well which percentage of the oil is coming from the landowner's property and which percentage of the oil is coming from someone else's property, because all the oil and gas looks the same. So it's fungible. So in that case, the neighbor cannot seek damages for drainage because there's no way to distinguish whose property the mineral interest came from. And then finally, can the neighbor seek equitable production? That is sharing of production. Oh, this traps a lot of people up. And the answer is no, they cannot, because there's no lease in place. Remember, pooling occurs under the oil and gas lease. There's a pooling provision. But if you are the landowner and you are drilling on your own land and you are paying all your own costs, then there's no oil and gas lease. And therefore, you can't force your neighbors or allow your neighbors to get a share of that production. So the question becomes, what do you do if you are being drained by your neighbor? And the only remedy is self-help. That is, the adjacent landowner's only remedy to protect her land from drainage is to drill her own well and attempt to recover her share of the oil and gas under her property. So this is the rule of capture. Now, usually when I'm teaching this in a class, I'll get someone to raise their hand and say, well, how under state conservation statutes, where it says you can only drill one well for 40 acres or one well for 640 acres, whatever type of well it is, and this is only 10 acres. So how is that enough for her to have adequate spacing? Well, under the law in Texas, there's called the Small Mineral Interest Owner's Rights. And if you are a small mineral interest owner, there is an exception to the pooling provision. So it says that if you only own 10 acres of land and you drill a well that's going to draw from 40-acre radius, that's okay as long as the landowner is doing it. We're going to carve out an exception from the pooling provision from the state conservation and spacing laws. And we're going to let this landowner who owns the 10 acres drill her well. Now, she's going to have to pay all the costs, okay? Drilling a well is pretty expensive, $6 million, well, $1 million and up. I heard of one well that was $21 million. So the average landowner is not going to have that kind of money laying around. But this is just to illustrate for you the rule of capture and to maintain that the landowner actually has the right to drill on her property even though it drains the land of another person or of other people. So there is these two different ownership theories by state, and I just want to go over those with you because I saw it in all the research that I was doing. I will say that I cannot for the life of me figure out what difference this makes. So let me just go over. There's two different types of ownership theories by state. There's what's called ownership in place, and there's what's called exclusive right to take, which is also known in Louisiana as the profit a prendre. Now, the ownership in place in Texas says that you own all the oil and gas under your land, period, end of subject. But in Louisiana, they say you only own your oil and gas if you drill. So if you don't drill, you don't own the property. So you would think that this is sort of mirroring the rule of capture, because in Texas you have the ownership, but what difference does it make if you don't drill it and produce it and reduce it to possession? So there's these two different ownership theories by state. If any one of you can tell me what difference this makes, maybe it's in a lawsuit, maybe the damages are different in a lawsuit. But I have researched this, and I cannot figure out what the difference it makes in terms of the rule of capture. So that's a little assignment for y'all if you want extra credit. All right, so then the rule of capture then is then modified by something. Now, remember we have the rule of capture. Remember in the beginning when you think about those old oil and gas producing fields, there was literally derrick after derrick after derrick after derrick of wells. Why? Because if you want to capture it, you have to drill for it. That's the only way. So they didn't want other people to be draining their oil. And so under the rule of capture, they put in their own oil and gas well. That was really the only remedy to defy the rule of capture, was to drill your own well. Okay, so then courts came up with this thing called correlative rights. And correlative rights basically modifies this rule of capture. They say, yes, you have to reduce it to possession to own it, but we want everyone to have an access to the common source of supply. So we're not going to let one owner overproduce so that other people can't benefit. So each owner has a right to a fair and equitable share of the oil and gas under his land, as well as the right to protection from negligent damage. So we enact conservation laws, and that way everybody's rights are produced. And it only applies if there's a common reservoir. So if there's a common reservoir, the rule of capture is going to be limited by the doctrine of correlative rights. That is to only have one well in a given area. And then this is where we talk about, the case is actually Ellis v. Texon, where Texon's negligence permitted one of its wells to blow out, draining large quantities of oil from Ellis land. And the result is that the capture, they did not have the right of capture. So each owner may sink as many wells as he desires and claim all the minerals he reasonably and legitimately produces, as long as he follows the conservation statutes. Now in Texas, that's the Texas Railroad Commission. These regulations and laws are designed to allow each owner that has an interest in this reservoir a reasonable opportunity to produce his share of the minerals and to prevent practices that would harm the common pool, like a blowout. So under this theory, each landowner is restricted to legitimate operations and must exercise his right with respect to the rights of other landowners. As such, no owner is permitted to operate recklessly. So that's the doctrine of correlative rights. Even though you have the right to drill on that land, you don't have the right to a blowout. You don't have the right to waste the reservoir that's under the ground. So the reason we have these correlative rights that modify the rule of capture is to prevent waste, to prevent spoilage, and to observe valid conservation laws. So this doctrine of correlative rights actually created the conservation laws that we have today. And what it's basically saying, if there's any waste or wasteful production techniques that will bring liability, as will negligent damage to the ability of the producing formation to produce for others. So it provides that each owner of minerals in a common source of supply has the right to a fair change to produce oil and gas from the webinar. Even if the statute does not mention correlative rights and waste, they must be implied. So that's the doctrine of correlative rights. So now we don't have this derrick after derrick after derrick after derrick of wells. They're evenly spaced out. And that way it protects everybody's interest in the reservoir. Okay. So another modification to the rule of capture is what's called the fair share principle. Now this was a case, Wronski versus Sun Oil Company. It was a Michigan case in 1979. And it modified the rule of capture. And it said each operator should have an opportunity equal to that afforded other operators to recover the equivalent of the amount of oil and gas underlying his property. So it modifies the rule of capture to exclude operations that are in violation of these valid conservation orders. So the rule of capture has been modified so that it excludes operations that are in violation of valid conservation orders. So then let's look at the rights of the mineral owner. Now, the rights of the mineral owner, sometimes you'll hear ownership described as a bundle of sticks. A bundle of sticks meaning you can sell it, you can mortgage it, you can lease it, you can do whatever, you put a lien on it, whatever you want on it. Those are all sticks in the bundle for ownership. So the rights of the mineral owner under this bundle of sticks theory is, first of all, the right to receive. That is, they are the ones that get the bonus, the delay rentals, and the royalty payments. The right to receive belongs to the mineral owner, not to a royalty owner or a non-participating royalty owner. The right to execute, it will apply to royalty interests that are spelled out in the lease itself, but it will not cover a non-participating royalty interest. The right to execute, that's also known as the executory right, meaning the mineral owner is the one who signs the oil and gas lease. If you take a lease from a surface owner, you do not have the right to drill on that property. So you have to get permission from the mineral owner, not the surface owner. So what about the surface owner? Do you have to get permission from the surface owner to drill for oil and gas? Well, that's the third right of the mineral owner, and that is the right to use the surface. The mineral owner has the right to use as much of the surface as is reasonably necessary to develop the minerals, even if he doesn't own the surface, even if there's a split interest. One person owns the surface and the other person owns the minerals. And how does this split interest, or this what's called a split estate, occur? Well, if you own fee simple absolute and you convey the surface to someone else, but you keep the mineral rights, I'm reserving the minerals, that is a split estate because one person owns the surface, that's known as the surface estate. The other person owns the minerals, that's known as the mineral estate. So if you want to drill on a given piece of property, and one person owns the surface and the other person owns the minerals, you would think that you have to get permission from the surface owner and from the mineral owner. But that is not the case. Under the rights of the mineral owner has the right to use as much of the surface as is reasonably necessary to develop the minerals. And this is what's called the dominant mineral estate. This is a case called Hunt Oil versus Curbaugh. It was a North Dakota case, 1979. And what it says is that the rule it established was that where the mineral estate is severed from the surface estate, that is, one person owns the mineral, the other person owns the surface, under this case, the mineral estate is dominant. That means the rights of the mineral owner trump the rights of the surface owner. So the mineral owner has the right to use as much of the surface as is reasonably necessary to explore and develop the minerals. So let's say that S owns the surface of Blackacre and M owns the minerals. So we've got S owning the surface, M owning the minerals, S for surface, M for minerals. I didn't want y'all to think I was using those initials for anything else. And an oil company comes along and they want to do seismic work on the surface. Now, seismic work involves getting trucks and getting workers on the surface, and they put these little, they're almost like things that you put a football on when you're going to kick the football. I forget what that's called, but they're like little cleats like that go into the earth, and they're connected by wire. And so they'll cause an explosion or a thump to the ground using these thumper trucks, they're called. And then they'll measure those land waves. And that is an indication to them of whether or not there's oil and gas under the ground. So, who do you get permission from if you're going to shoot seismic? And the answer is, because you're evaluating the minerals under the earth, you have to get permission from the mineral owner, not the surface owner, because you're looking at the minerals. That's the whole goal. Now, I've had many people that work right-of-ways tell me that all they do is go and knock on the door where the property is and get permission from that person. They don't do any kind of record check, so they're just assuming that the surface owner is the mineral owner. And so they're taking a risk there that it's not. And if it's not, and they go onto the land and shoot seismic without the permission of the mineral owner, they could be in violation of trespass. But what you need to remember here is that the mineral estate is dominant. Now, we do not have to pay the surface owner to use the surface. It is embedded in this oil and gas case, Hunt Oil versus Kerbal. We have the legal right to use as much of the surface as is reasonably necessary, even if you surface owners say no. So now, do we compensate these surface owners? Do we compensate these owners? Raise your hand if the answer is yes. Yes, good, Stephanie. I see, Liz, I've seen you join us. Excellent. Y'all all got it right. Yes, we compensate these surface owners. Why do we compensate the surface owners if under the law there is a theory of the dominant mineral estate which says that we don't have to, which says that the mineral owner's rights trump the rights of the surface owner? Well, the reason is public relations. You know, if we have a little old lady surface owner and the big bad oil and gas company comes and drills on her land and she complains to, 60 Minutes, for example, and 60 Minutes comes out and he asks the president of your company, why aren't you paying this lady? And your president says, well, under Hunt Oil versus Kerbal, this is known as the dominant mineral estate, Anderson, where one person owns the surface and then another owns the minerals, the mineral estate is dominant. And so we can legally use as much of the land as we want to. Is this a true statement? Absolutely. That is a true statement. But how is the public going to perceive that? The public is going to perceive that as the poor little old lady and the big bad oil company. So to keep us off of 60 Minutes, to keep Anderson Cooper from knocking on your president's door, we say that we will pay you, surface owner. We will pay you. Another reason we pay them is because this is a long-term relationship. We are going to be on their surface and we want to be in, have a good relationship with them, so that they will allow us to drill for oil and gas. Now, I know you say, well, allow. How can they not allow? It's the dominant mineral estate. But they can make your life pretty miserable. They can have dogs waiting for you at the gate. They can lock the gate. They can meet you with a gun at the gate, So, they may not understand this legal theory of the dominant mineral estate like we do. So we want to get along with that surface owner. We want them to feel like they are getting something out of this too. And if they feel that way, then they're going to be easier to deal with, because you're not just saying, okay, we're not going to pay you anything, but we're going to tear up your land. Now, we also have a responsibility to, what's that word? Dang it. remediate the surface. So once we cause all this damage, we have the responsibility to go back and fix the land to as it was before we got on that property. But in the meantime, the property is going to be pretty torn up. Another thing I will tell you is that certain states have rules about this or laws about this. For example, Oklahoma has a surface mineral owners' rights law. And what it says is that you, oil and gas company, even though there's this dominant mineral estate, you, oil and gas company, have to attempt to pay the surface owner something. Okay? So even though we have got this legal theory, state statutes can vary. And Oklahoma state statute says you've got to compensate that surface owner. Now, the surface owner cannot hold the oil and gas company over a barrel. In other words, they can't say, well, we want $1 million for you to drill on our land. And if you don't give us $1 million, we're not going to let you on our property. They can't do that. All that has to happen is the oil and gas company has to make a reasonable offer to the surface owner. And if the surface owner says, well, I'm not going to agree then, I'm not going to accept any payment, what's going to happen is we're going to tell that surface owner, you can either take this money and we're going to drill on the surface, or you can leave this money on the table and we're going to drill on the surface. So no matter what you decide, whichever way you go, we're still going to drill on the surface. But we will, as a matter of law in Oklahoma and as a matter of public relations in other states, we will pay you a sum of money. But if they say, I'm not accepting it, we still have the right to drill. We do not have to have the permission of the surface owner to drill on the land. Now, there is one exception to this, and this is what's called the accommodation doctrine. So sometimes we do have to accommodate this surface owner, but only if certain factors are there. And these are the factors. So this is called the accommodation doctrine. And what it says is that there is a right to prevent injury. The accommodation doctrine says that there is a right that the landowner has, the surface owner has, to prevent injury or negligence to the surface state. And we can do that if these situations exist. One is if there is a pre-existing use of the surface. So let's say Farmer Brown and his family have been drilling this property for generations. So they were already using the surface. That's called a pre-existing use of the surface. And let's say that Farmer Brown can say, hey, there's another way we can do this, and that other way to do it is available on my land. If these three factors exist, in that case, we will have to accommodate the landowner. Now, that's not saying we still don't have the right to drill, but, and this is the case, it's called Texaco v. Getty. You're going to love this. So what happens is, let me make sure I got my facts right. Okay. So in this case, let's say this farmer owned property, his family owned this land for generations. And in the Texaco v. Getty case, there's something called a rolling irrigation unit. Y'all know what those are? Those are like, there's one tractor in the middle, and then shooting out are these long arms, and spaced evenly over the arms are these little hoses that, water the earth, okay? And so this is called a rolling irrigation system, and they're huge, as you know, and they're very expensive. It's a very expensive piece of equipment to buy. So when Texaco wanted to drill on Getty's land, Getty said, wait a minute, how am I going to water my plants? I've staked $1 million in this piece of equipment, and now you're going to come on and use the surface, and that piece of equipment's just, I can never use that again. And my crops are not going to get watered. And so this was a case that was presented to the court, and the court said, look, if you can show that there's a pre-existing use of the surface, that is, his family has used this for generations, if there's a reasonable alternative method available, and that method is available on the lease tract, then you have to use that alternate method. Now, do you know what the alternate method was in this case? The ultimate, well, shoot, I just lost my train of thought. The ultimate solution was that they would drill the well below plow depth. Okay, so the top of the derrick, the top of the derrick is below the earth, okay, below the ground, so that that rolling irrigation system can still, cover the whole farm. There's no well in the middle of it that's bumping into it. So that is the case, and that is the case law that still stands. So they said that there was a reasonable alternative method and it was available on the lease tract. That is, you drill the well below plowed depth so that it won't interfere with the roller sprinkler system that the farmer used. And then he also presents evidence that other leases in the area are using cellar pits to lower the height of the pumping units. And then he talks about how much it will be. So Farmer Brown is going to win this lawsuit, or Getty's going to win this lawsuit, because these three factors existed. These three accommodations were made. How are we doing on time? Okay, so just to go over this, the mineral owner, if you own 10 acres, you have the right to develop your property without leasing. That means you have the right to, you decide to drill a well on your leases. You still have to pay for all the costs, but if it's a successful well, you don't have to share it with anybody. Does the mineral owner have a duty to develop? Raise your hand if you think they do not have a duty to develop the land. Right, they don't have a duty because it's their land. If there was a duty and you owned land, there would be a legal obligation for you to go out and drill a well. No, especially when oil prices are where they are right now. There's no duty to develop, but there is a right to develop. So I want you to understand that distinction. Okay, next we're going to look at different types of ownership and how that impacts oil and gas law. So the first one that we look at is co-tenancy. Now, I know you're familiar with this. This is where more than one person own an interest in a piece of property, and instead of this person owning 3 acres, this person owning 4 acres, this person owning 5 acres, they all own a percentage of every molecule in that well. And so they are entitled to a share of the production. All right, so this is the case, Prairie Oil and Gas Company versus Allen. And this is an Oklahoma case, 1924. This still stands, 1924 case. And let me just give you an example in my own family. Let's say that each of these represents one of my siblings. Okay, this is me, and this is one of my other siblings. And my father owns this farm in Opelousas, Louisiana. Okay, the oil and gas company approaches all of my siblings, and we all own equally in this land. So what is this? 1, 2, 3, 4, 5, 6. We each own a 1/6 interest in this land. And the oil and gas company comes and leases from all my siblings. And I say, well, I'm in the oil and gas business, so I want to go ahead and pay my own share. All right? So I don't agree to lease. I don't want there to be a lease. And so can I, just because I won't agree, can I prevent the other oil and gas companies, the other lessees, from drilling? Let me rephrase the hypothetical. Let's say that these are all surface or mineral owners on this land. And let's say that one person, let's say 3 people want to sign leases and they will allow an oil and gas company to drill. And the other 3 people say no. Grandpa never wanted us to use this land for oil and gas. He always wanted us to keep it pristine for dairy cattle or whatever it is. Can these 3 people prevent the 3 people that signed the lease from there being production? And the answer is no. In other words, all the co-tenants don't have to agree. So you can have one co-tenant that never wants to sign or that disagrees, and all the others do. The oil and gas company can still drill on that land, even though there was a co-tenant that did not consent. So it says that every co-tenant can drill and produce or lease his undivided share, his 1/6 share, without the consent of the other co-tenant. So there's none of this majority rules. There's none of this, it's got to be unanimous. No, every person that owns an undivided interest has the right to do what he wants on that, including allowing an oil and gas company to drill on the land. Now, he does, though, have to account to the others for their rightful share. Okay, so because they all own an equal 1/6 on this land, whatever production there is, it has to be given to the other co-tenants, even if they didn't agree. So now, but these other co-tenants have to pay for their fair share of the drilling cost. Okay, so if you're one of these other siblings and you say, well, you know what, that's not fair. I didn't agree to drill on this property. Y'all went ahead and drilled on this property, and now I'm supposed to pay for a share of the working interest cost? And the answer is yes. And the way we explain it to this non-consenting landowner is that we are going to take from the profits, we're going to take from the profits that you didn't have before, that now you have, we're going to use those profits to pay for the drilling cost. And then once the drilling costs are paid, then we'll start giving you your share of the interest. So that is the co-tenancy law. So yes, we don't have to have universal consent. There's no unanimous. There's no majority rules. Any one of these owners can decide to allow an oil and gas company to come onto their property, but the other owners are entitled to a share. So when we have this, we'll see this written on deeds as an undivided 1/6 interest, okay? So the only way to divide an undivided interest is to partition it, either by partition in kind or partition it by sale. Partition in kind means that, for those of you that remember in Module 2 when we had that family feud, and the judge says, okay, this person owns this tract, this person owns this tract, you know, Henry Locklear owns this tract, you know, they all own these specific tracts. They took what was an undivided interest or co-tenants and they divided it out so they each own their interest. Partition by sale means we sell the whole property and we'll then split whatever the revenue is that we got from that. So in this case, Schnitt versus McKellar, this is an Arkansas case, it held that the mineral interest could also be the subject of partition. So you could either partition it in kind by saying this person owns this part, this person owns this part, or you could sell the mineral interest and everybody would get a share. So that's co-tenancy. Now another type of co-tenancy or another kind of tenancy is what's called the life tenant. Now in that case, you remember that a life tenant is someone they own as husband and wife. Let's see that husband owns property. Husband owns property. Oh, sorry. Husband owns property. Okay. And he's married to his wife. And what he wants to do is he wants to leave his property to their kids. Okay. 1, 2, and 3. But his fear is that if when he dies everything goes to his wife could remarry and have another husband and have children by that husband. And then in that case, husband number 1's kids would never be entitled to the interest. So husband says, okay, honey, I'm going to give you the property, but only for your lifetime. And when you die, that property is going to pass to our kids. So you see that set up a lot in on oil and gas leases. Is this notion of a life tenant. So the wife is known as the life tenant, and the kids are known as the remaindermen for each of these. So if she only owns for her life, she does not have the right to sell it. She does not have the right to mortgage it. She does not have the right to convey it. So the question is, if you have ownership, let me erase this. If you have ownership, where the wife owns as a life tenant and the kids are the remaindermen, who do you take the oil and gas lease from? So, can the wife grant a valid lease? Well, yes, she can during her lifetime, but not beyond that. Can the son grant a valid lease, or can one of the remaindermen grant a valid lease? And the answer is no, because they don't really own the property yet. Once she dies, they'll own the property. And so the way you protect yourself is that both the wife and the son, the remainderman, have to sign the lease to make it valid. That's the trick with the life tenant. Both have to sign. Now, there is something called an open mind doctrine. And under the open mind doctrine, if the lease already existed, in other words, if it was in place, then the wife could own it outright, and she would be entitled to the royalty payment. That's called the open mind doctrine. So that's life tenants. Oh, here it is. When there's a lease in place, that is, let's say husband and wife are married and there's an oil and gas lease in place on the property, when the life estate is created, the life tenant is entitled to payments under the lease. So that means they're entitled to the lease bonus, the delay rental, and the royalty. And the remainderman gets zero until the life tenant dies. Now, I know this says royalty, but in my experience, the life tenant is always paid the royalty interest. It is called fruits of the land. So in Louisiana, we call this the life tenant. I'm sorry, we don't call this the life tenant. We call this the usufruct. So the life tenant is known as a usufruct. You have to be real careful how you say that word. A usufruct. And it comes from the Latin, the use of the fruits. So she has the right to use the fruits during her lifetime. That means she's entitled to a royalty payment. And almost every company that I work for, they pay the royalty to the life tenant during her lifetime. But in this case, it's saying only if there was an existing lease. So there's some confusion about that. If anybody wants to research that, that would be a great topic to research. Okay, very quickly now, if you go onto somebody's property and you don't have a valid lease, and that might be because the legal description is incorrect or you didn't get the mineral owner to sign, this is known under the law as trespass, and you can sue for trespass. Now, ordinary trespass would be if you went onto someone's land without their consent, or if the lease expired while you were on their property and you didn't leave. That would be a lawsuit in ordinary trespass. Another one is slant well drilling. Remember, that's where you have a well here. Pitiful, pitiful, pitiful drawing. You have a well here, and they go, whoop, they go over here and they get this neighbor's land. That's called slant well drilling. That's another form of trespass. There's another kind of trespass that's called seismic trespass. That is the situation where you go and have to ask permission from the mineral owner to shoot seismic. If you don't, your company could be sued for a seismic or geophysical trespass. There's another kind of trespass that's called damage to speculative value. And that is, even if the mineral owner gives you permission to go onto the land and shoot seismic, if you then publicize those findings and say there's no oil and gas under this land because we shot seismic, that is what's called a trespass in a damage to speculative value. This is called the Kishi case. I'm sorry, I don't have the site for you. Let me see if I have it in my notes. It's Kishi versus Humble Oil. I'm sorry, I don't have that site for you. But what it says that if we give you permission to shoot seismic, that information is for you and for you alone. If you go out and you broadcast that information, or you let other oil and gas companies in the area know that you don't think there's any oil and gas under this property, you have just damaged my speculative value. It's kind of like a slander lawsuit. You know, you've slandered my property. You've said it's no good. You don't have the right to do that. Yes, you have the right to shoot seismic on my land, and you have the right to those results, but you don't have the right to share that with everybody else. So those are the trespass lawsuits that occur when we're talking about drilling on a lease. Implied covenants. There are certain clauses in the oil and gas lease. Actually, they're not in the oil and gas lease, but they're implied in the oil and gas lease. So even if the oil and gas lease doesn't specifically say so, the operator has to act as a reasonable, prudent operator. Now, I used to say a reasonably prudent operator, okay? And I got corrected in one of my classes one time because a reasonable, prudent operator is different from a reasonably prudent operator. And the difference is, you know, you're reasonable or you're, it's reasonable enough, you know. He's reasonably prudent. No, not reasonably, reasonable, prudent operator. And that prudent operator has the duty to develop. They have to reasonably develop it, and they have the right to further explore it. They have the right to protect against drainage, and they have the right to market it. So we'll talk about this in the Implied Covenants webinar, but I just wanted to introduce you to these. The duty to develop, the duty to explore, duty to protect against drainage, and the duty to market. Okay, and that wraps up our presentation for today. So here's what we talked about. We looked at the different ownership theories, the Coelum doctrine. That's called the heaven to hell doctrine, and that says you own as much of the earth all the way down to hell and all the way up to heaven. This was modified by the rule of capture. In the rule of capture, you only under the rule of capture, wildlife belonged to the world until you shot that duck and reduced it to possession. Same thing with oil and gas. If you drilled and that oil was drained from the land of another, because oil is fugacious and because oil is fungible, there's no way for us to distinguish whose oil that property came from. So you drill it, you produce it, you become the owner of it. And then we looked at the ownership theories, ownership in place, and the non-ownership theory, or the profit a prendre. I explained those to you, but I said I don't really know how they apply or why they're relevant. I've researched it. Maybe it's in a lawsuit. I don't know. And then we looked at the doctrine of correlative rights. And the doctrine of correlative rights says that everyone has to do their best to protect the reservoir. So in other words, just because you could drill on your land, you don't have the right to cause a blowout because you're then violating others' rights. Now, the doctrine of spacing and pooling came out of the doctrine of correlative rights to maintain the reservoir. And then we looked at the rights of the mineral owner. We talked about the right to execute, the right to receive royalty, and the right to use as much of the surface as is reasonably necessary. And then we talked about how a landowner would protect those interests through different trespass actions. And then we looked briefly at the implied covenants of the lease. So that concludes our presentation today. Are there any questions that you may have about this that I can answer for you live? If you could just write it in the question box, I'll be happy to answer it for the class. Okay, Stephanie, were you, Stephanie, the ordinary trespass, to go over that again, that is if the oil company goes on someone's land and they don't have a valid oil and gas lease. Now, this really comes into play a lot of times if the lease expires. So, when we go over the oil and gas lease, they have this delay rental clause. And if that is a payment that's due 1 year from the date of the lease date, and if that payment is a penny off, if it's a half acre off, if it's a day late, the entire lease will expire. So in that case, the oil and gas company is going to have to go back to the mineral owner and try to renegotiate a lease. If he cannot renegotiate that lease, he is trespassing on the property. It is the oil and gas lease that gives him permission to be on the property. So that is what ordinary trespass is. Liz, I'm glad you were able to make it. I was worried about you. Anybody else have any question? That was a really good question. Okay, well, if there's no other questions, I'm going to stop recording now. And I hope you have a great rest of your day.